group here, 1987, an old student of St. Louis Secondary School, Kumasi, Ghana, an immigration and property lawyer or attorney who has a legal firm as Ivy Woods Consulting Legal, currently based in the United Kingdom, and also the CEO of Co-Cave Properties, a real estate developer, all licensed and registered in the UK. It is a huge honor for me to be hosting this program. We've met tonight to be educated on current updates in the areas of marriage and divorce, US citizenship and traffic violations. Before I introduce to its panelists, I want to take the opportunity to thank everybody on this Zoom meeting for making time on your busy schedules to be here. Judging by the depth of knowledge, the distinguished legal practitioners on our panel tonight possess, and so I trust that the program will be hugely beneficial for all of us. I will therefore begin by introducing our special guest for tonight, Her Honor, Mrs. Hathia Menu, a Slopsa, which means she's an old student of St. Louis Secondary School, Kumasi, and a circuit court judge currently based in Ghana, who will give us updates on marriage and divorce. Let's give a hand to her. Our second distinguished panelist is Our Lady, Mrs. Equia Ohinichini Abuaji, an old student of Wesley Girls High School, Wegehe, a licensed attorney in the United States and Ghana, who focuses on immigration and trademark law. Her firm, AK Poku Law, is based in Virginia, United States, but represents clients in all the 50 states in America. Finally, we have our only Honorable Kat Christian Ansa, BD 121, Akatachie, an old student of Opokuwari Secondary School, and also the Akatachie National Security in the United States of America. Once again, I welcome you all. I will crave your indulgence and ask that we all hold our questions and wait until the presentations from the panel are over. The panelists are given a time limit of 10 minutes each for their presentation. To the audience, kindly raise your hand for questions and answers. Now, without wasting any more time, I will call upon Our Lady, Equia Ohinichini Abuaji, to start off our program for the evening with their presentation. Thank you. Lawyer Equia, are you ready now?
Hello, Lady Ivy. Thank you so much for the introduction. Yes, I'm ready.
Okay, you can start the program. You can start your presentation now.
All right, good evening, everybody. So as Lady Ivy said, my name is Ikea. I'm a U.S. immigration attorney here. So today we're going to be talking about what's happening in the U.S. immigration arena. As we all know, ex-President Trump, was just taken out of power. And during his time between 2017 and 2020, he actually implemented over 1,000 policy changes just for US immigration law. So that means that almost every single day we would wake up and there was a new change or there was a new law regarding immigration. And these policies or these new changes were not immigrant friendly. So they were, they sought to make immigration law very difficult and sought to make immigrants have a difficult time to become, green card holders and US citizens, okay? And also there are about 520 immigration judges throughout the US. Ex-President Trump actually appointed 2/3 of these immigration court judges, and these are lifetime positions. And the people he appointed are also, they have very similar views just similar views as President Trump. And of course, people were very worried that he has appointed very young judges to fill all these immigration courts. And so their judgments are going to have an impact for decades to come, you know, in US immigration law. So on that basis, President Joe Biden, he was recently elected as president. And when he came, he admitted that President Trump had dismantled the US immigration system. And so he wanted to reform the system. And he introduced through his party the US Citizenship Act 2021. And it's a bill. A bill is just a proposal. It hasn't been passed into a law, but this bill was introduced just about 3 months ago, and it's the immigrant's dream. It's made up of, you know, all the great stuff you can think of. And unfortunately, though, it's received a lot of backlash because, of course, there are many people who do not believe that immigrants who came in unlawfully or who have overstayed their visas deserve a chance. Okay, so that's what's currently happening. And this bill was introduced. However, they haven't yet voted upon it. What they decided to do instead was to pass piecemeal legislations regarding the dreamers. And also, so the dreamers are the young people who came to the US under the age of 18 through no fault of theirs and are illegal or undocumented. Also, there was a Promise Act, which is meant for the TPS and DED. TPS is temporary protected status. DED is deferred and forced departure. These are temporary immigration reliefs that are given to people who are coming from countries with maybe civil war or extraordinary circumstances that make it unsafe for them to return to their country. And so if your country is designated a TPS country, it means you can stay here temporarily. And then when the unrest is over or whatever, you can go. So you are given a work permit. So the Promise Act, the American Promise Act, covers these people, the TPS and DED. And then also the House also voted on the Farm Workers Modernization Act. So the piecemeal legislation, which covered the American Promise and then the Farm Workers Modernization Act, was voted upon. Well, were voted upon the two bills, and now they have to go through Senate. And as we know, there's a majority. You know, the House is split in two. Of course, we have the Democrats and the Republicans. The Democrats have majority in the House, and then it's a slim majority. But with Senate, there's a 50-50 split with Vice President Kamala Harris breaking the tie. However, there's a procedural hurdle, which is known as the filibuster, where senators can stand up and prevent a bill from being voted upon. So they can continue to debate until, you know, the bill is not voted upon or whatever. So the Democrats have to find a way to overcome this filibuster. So currently, as we have it now, the US Citizenship Act hasn't been voted upon at all because the Republicans are not in favor of it. And also there are also some Democrats who are also not in favor of it because there was they did some checks and they realized that even the Democrats, not everybody was on board with the US Citizenship Act. And so they put it on hold and they're planning to reintroduce it in April. So let's take a look. I don't know if I have a few more minutes. Let's take a look at what the contents of the US Citizenship Act is. There's going to be a temporary legal status, which is known as the lawful prospective immigrant status, which will be granted to people who have been defined as non-citizens. So a non-citizen, according to the US Citizenship Act, is somebody who is currently out of status, and should have been out of status from 1st January 2021. And so people, have been reaching out, people who are on B2 visas, and then they are planning to overstay so that they'll take advantage of the amnesty if it comes to pass. But unfortunately, they will not qualify because you should have been out of status by 1st January 2021. And also people who have green cards or other immigration benefits or are in status some way, somehow, will not qualify for this act. And so the lawful prospective immigrant status will be evidenced by a card. It will be a documentary evidence valid for 6 years, renewable at the end of the term. And then at the end of 5 years, you can apply for green card And then at the end of, you have the green card for 3 years. At the end of 3 years, you can apply for citizenship. Before this status will be given to you, there'll be background checks. And of course, you have to pay your taxes. And pretty much that's it. The people will have the opportunity to work and then also to travel for, not more than 180 days, because that will break your, continuous residence requirement. And then they will also be given social security cards as well. So let's now talk about the border crisis. So there's a border crisis currently. When people heard that President Joe Biden was come to give, an amnesty to undocumented people, everybody was rushing to the border just to try to come into the US. And so the Republicans just about last week introduced the dignity proposal. It's their version of the US Citizenship Act, and that actually prioritizes border security. And then after prioritizing border security, then they're saying that we can now talk about legalizing, the undocumented people. And for them, they don't want the undocumented people to be pampered. They want them to do a 10-year redemption program. And so the 10 years, they're going to be sort of penalized. You're going to be paying monies into the American Business Fund. They're going to be paying fines. And then after that, there's going to be a 5-year redemption program. There's going to be another 5-year program. And then during that time, they will determine if they want them to get green cards. But for the Republicans, the 10-year program is just a work visa, and they'll be, the undocumented people will be given the opportunity to work and cater for their families. So it's just a draft now. The Republicans haven't yet brought out the text of the bill, but it's actually very good news because a lot of undocumented people are not really looking for citizenship per se. They're just looking for a work visa, like just any document to be able to work and then to provide for their families. And so if this bill is introduced, what I'm telling people is that they have to start getting ready. I speak to people and they don't even remember what they put on their documents when they were applying for visas back home in the consulates in Ghana. Some of them, went through connection men, and then they were attached to families and said, look, we your mommy, go with them. And then they were granted that we're coming for graduation. They don't remember their mother's names that were used or whatever, all sorts of concoctions. And so you need to start requesting your immigration history. That's the FOIA, Freedom of Information Act, which gives, undocumented persons the right to actually petition the government and tell the government, look, I want information that you have about me, that, depending on what your immigration history has been, we'll know where to, FOIA your documents from. So we have the USCIS, which is the United States Citizenship and Immigration Services. If you've done petitions, we have the Custom and Border Protection. If you've, had encounters at the port of entry when you're trying to come in. We have the EOIR, which is the Executive Office of Immigration Review, which is the immigration court. And so if you have been through deportation proceedings or you have obtained removal proceedings, that's where you need to FOIA from. And then, we have DHS, we have the OBIM, Office of Biometric Information, if you've had, biometric discrepancy. So there's a whole variety of places you need to request your FOIA from, and then that will help you get prepared for, after the senators and the representatives finish their gymnastics in Congress, you are ready, because it takes a while for the FOIA to be ready. Sometimes it takes 8 months, 9 months, and you will need this information because sometimes you need to make sure that if there are any inconsistencies, if any of these bills are passed, when you are applying, you can't say that your mother's name is, let's say, Martha Amwa, and then from Ghana, when you were coming, you said your mother's name was Ajwa Asamoah or something. So there will be that inconsistency, and that may cause problems for you. And so if there are inconsistencies, we have to find ways to address those in the new application that you will be making in preparation for whatever bill for whatever law that may be passed. Is my time up already?
Okay, I'll give you another 5 minutes and that's it.
Well, pretty much. I think I've covered everything. So yeah, the FOIA, as I was saying, is really important because, as I said, a lot of people, sometimes what happens also is that people have filed petitions with the USCIS. You ask them, okay, when did you say file this I-130 petition, which is a petition for an alien relative? And they don't really remember. And it must have been maybe 6 years ago. And I was denied. What was the basis of the denial? They don't remember. You see, all this information are things that we should have, because if the US Citizenship Act is passed, or whatever new bill is passed into a law, when you are filing applications, they'll usually ask you, for example, what did you apply for? What was the last immigration benefits you sought? We don't know what questions are going to be on those applications, because remember, they're going to be doing background checks and everything. And so they're going to have all your immigration history. And it's important that the information you provide is either consistent with what you've provided in the past, or if it's inconsistent, you have a possible explanation to why you gave that explanation. Also, to be able to apply for the US citizen, when the US Citizenship Act passes, to be able to apply, you need to establish your identity, and then you also need to establish continuous legal presence. You need to start gathering documents to establish your identity, like your passport. Even though you are undocumented, you can apply for your passport using the Ghana embassy in the US here in DC, or in New York. You can just show your birth certificate or whatever, and then you get a Ghana passport, which will be valid. And then, pretty much, yes, just documents showing your continuous legal presence, like tax transcripts, medical records, mortgage leases, and the like. So I think that I'm done. Maybe I can end on this note. Well, the dignity proposal that was presented by the Republicans was introduced by Maria Salazar. She's, I think, the Floridan representative, and she was backed by 9 other representatives or congressmen. And so it's a positive thing, because it looks like they're interested in working with the Democrats to find a problem to the legalization issue of undocumented people. And I like to give this visual. So imagine that you are in a big house by yourself and you are sleeping upstairs, and you have 2 people lurking in your basement. You don't know what their names are. You don't know what they look like. That's the situation now. It's not good for your security to be sleeping upstairs when you don't know the names of the people who are lurking in your basement. That's just how it is here in the US. Like, the undocumented people, they don't know, the government doesn't know who they are, where they work, what they do. And so it's in the interest of the United States to actually try to find a way to legalize these people, and then identify them for the purpose of national security and other reasons. Thank you so much.
Well, thank you. I think you've told us enough. Thank you so much for that. Okay, next is Honorable Lawyer Christian. Can you continue, please?
All right. Thank you very much, Lady Ivy. And then I want to thank everyone, particularly our judge. Your Honor, we salute you for joining us today. And then also to everyone for spending time to be here. I've been asked to talk about traffic offenses. And basically we all drive. If we don't drive, we've all been in cars before. And so this information is still relevant, even if you don't drive, because you'll be in a car, someone will be driving, and you could also give the personal advice. For the sake of time, we will not be able to more or less go through the various specifics, but I'll give a general overview. And then I also summarize encounters with police, especially those of us who reside in the US, and I've seen so much bad news regarding how police encounters do end for some people within the country. Just to start from, we want to look at traffic violations. And basically in the US, violations are put into 2 main categories. We have moving violations and non-moving violations. We begin with the non-moving violations. Non-moving violations are violations that we do get ourselves into when our cars are parked. And I'm very sure some of us may probably have gotten a ticket for parking at the wrong place or parking and not paying for a ticket where there's a meter. And those are some of the non-moving violations that we do encounter. We will not spend a lot of time there because they don't carry points. Non-moving violations do not carry points. And so that is non-moving violations. So anytime your car is parked and you get ticketed for not parking well, parking inappropriately, or not paying for parking, you are actually indulging yourself in non-moving violations. Again, here, non-moving violations do not have a lot of weight as compared to moving violations. And so moving violations, which I'll be focusing more, are the most important ones that most of us should be aware of. And the fact that most of the time, most of the time, if you encounter a law enforcement officer or a police officer, it will be through driving, and especially when your car is moving. And so it's called moving violation because you're gonna be at fault while your car is moving. And for the most part, we separate all moving violations from one drastic moving violation, which has the propensity to more or less come with a very grave punishment, and that is DUI or DWI. DUI is driving under the influence in some states, and in other states like New York, in states like Massachusetts and other places, you have driving while intoxicated. It doesn't mean that you are driving, it doesn't mean that you've taken alcohol. Being under the influence could be under the influence of any drug or anything that could have an impact on your being as an individual. And so all other moving violations are actually separated from DUIs. And I want to talk about DUIs. And the reason why DUIs are very important is that almost every violation that you engage yourself in immigration may not have, let me say, a jail sentence. But in some states, DUI do go beyond a mere violation. Some states have actually criminalized DUIs or DWIs. In New York, for instance, if you are caught driving and then you are under, if you blow your BAC, the BAC is your blood alcohol content test that it's kind of meted out when a police officer more or less stops you. And if you blow beyond a certain percentage, you could actually end up in jail. And so mostly the advice we give to individuals in this context is that when you drink, don't drive. These days there are a lot of Ubers, there are a lot of taxis around. You could easily get an Uber if you want to find your way around. And so basically the advice that is that if you drink, don't drive. But in case you have taken something and you still believe that you want to drive, normally we want to encourage that at least you eat very well before you drive, because when your case comes up in court, there are so many factors that we actually balance before a punishment is meted out. And one of the most important factors is the time you took the alcohol, the drug, or whatever that you are being influenced with, the time you ate, and other circumstances in which the officer may have encountered at the time the person stopped you. And so you don't want to be caught up driving while you're intoxicated. Again, it could land you in jail. And we also encourage that at least you don't want to be found guilty of DUIs within 6 months of each other. When it happens like that, in almost every state, you're likely to have your license suspended. And then there are other DUIs which we also encounter, and those include speeding tickets, reckless driving. Apart from that, using your phones while driving in this day and era, it's become an offense in so many states. In New Jersey, it's an offense. In New York, it's an offense. You can't use your phone while driving. In Massachusetts, it's an offense, and they come with very huge fines, even though it may not subject you to an imprisonment. the first time you do it. But just to go around there are 3 sentences or 3 statements that we do tell people, or we do give every road user, including myself. And it's that when you're driving, keep your eyes on the road. If you're driving, make sure you keep your attention on the road. And if you're driving, you don't overspeed, or you don't go, I mean, in Ghana, we say overspeeding, here we say speeding. And the point is that if you're able to follow these 3 guidelines, you may be able to more or less navigate yourself through all the offenses that come along with driving. And so you want to always keep your eyes on the road. You always want to keep your attention, and you always want to make sure you are not speeding. When it comes to speeding tickets, most states do have very huge punishment for speeding tickets where a driver is found going about 30 miles per hour over the allotted speed ticket. And so in a state like New York, I'm using New York as an example because I do practice around the New York, New Jersey area. So you hear that a lot. So in a state like New York, if you are going above 30 mph, it means that you may still you could also have a ticket for reckless driving. So if you're driving at a place where there are traffic lights and you're going above 20 miles per hour, you could also be subjected to other tickets, which includes reckless driving. If you have a minor in the car, or if you have someone who is an elderly person or someone who is not well in the car, you can also be subjected to another offense, and that is very huge in the state of Pennsylvania, especially in Philly. You could also get a ticket for endangering the lives of others. And so sometimes just one scenario could subject you to so many tickets. And although sometimes you're able to fight some of them, if you have about 4 of them, the moment you go to court, you are likely to pay one. And so we always want to encourage you that at least with the speeding tickets, you want to make sure, even if you are running late for an important assignment, make sure at least you adjust yourself and you don't go beyond at 20 miles per hour. Because if you do that, then you are really going above the curve. And once that happens, the kind of punishment that you could be subjected to will be very huge. Again, we also have to understand that the violation system, the traffic violation system, is a system that is largely used for fundraising. I mean, in so many communities, so many towns, that is how judges get paid. That is how police officers get paid. In fact, the officer who is giving you a ticket in a state like Pennsylvania, in a state like New York, is going to get a commission when you are fined by the court, or when you are found guilty for driving. I mean, driving whatever based on the charge that the person has actually hit you with. And so you want to be very mindful of that. It's very, very difficult, although most of these tickets can be fought. It's very, very difficult to actually get yourself completely exonerated when you get these type of tickets. And so because of the nature of the fundraising, which is basically underlining these things, that is why it becomes very difficult to more or less deal with these tickets. But a huge component with the driving issue is our encounters with police officers. And unfortunately, most of these encounters have ended in fatality. People have died because of this. We have people beaten because of this. People have been shot because of this. And for the most part, we just want to give you 1 or 2 counsel regarding these kind of encounters. We have rights. We have certain rights that are given to us by the Constitution, by some amendments of the Constitution that more or less govern or that protect you as an individual. For instance, you cannot be subject to an unreasonable search or seizure. And so a police officer cannot just stop you and then begin to look into your car and then begin to look into your trunk, just trying to find out if there is something going on wrong with you. That is, the law does not permit it. But again, the police officer in most states have the chance to stop you. The bar for most of the states is that the police officer stops you when he believes you've committed an offense. And so when you go to a state like New Hampshire, a state like Massachusetts, you cannot be driving your car in an orderly manner, going within the speed limit, I mean, not crossing red lights and then have a police officer stop you. That is not lawful. But again, even if you've been engaged in an unlawful stop, the law imposes on you to also comply, and then just you can have a conversation with the police officer. And then I'll come back to what happens in there. And so in some other states, like New Jersey, a police officer can stop you and then just engage with you. And the law allows them to do that. And I think the caveat or the main reason behind it is that there are sometimes police officers should be given the chance to make sure that people are doing the right things, to make sure people are fine, people are okay and all that. And so it's not any time that the officer will stop you in such a state that you should impugn that there is something wrong or you've committed an offense. But the point is that anytime the officer is stopping you, the officer wants to give you a ticket because he or she profits from giving you tickets. That is how they get promotions. That is how they get their commission and they get paid. And so what are you supposed to do in that encounter? For the most part, you have to be relaxed. You have to be composed as ever. You have to make sure you don't, I mean, most of us get caught up in being defensive. The moment you are stopped by a police officer, we always want to encourage you that just relax and make sure you are yourself. And the point is that one, don't argue with the police officer. You don't argue with the police officer. When the police officer stops you, the person will ask for your license. That is lawful. You are supposed to give the license to the person. Again, you are supposed to give your license before the officer tells you why you are being stopped. In most states, the law does not place it as an obligation on the officer to tell you why you are stopped. But you as an individual can request or ask the officer why he or she has stopped you. And the moment you ask, the officer is also expected to tell you. The law mandates that they tell you. Sometimes you may get a ticket and you may not have committed the offense the officer is giving the ticket for. We encourage you not to engage in any dispute or any argument with the officer. That wouldn't help you in any way, because one, the officer is not a judge. Two, the officer, most officers are not even lawyers. They just go in and then they present what they have as more or less evidence or as something to back the claim against you. So don't waste your time. Don't waste the officer's time just engaging the back and forth argument. Don't get angry. Just be composed. And then normally we encourage people to be very attentive, listen to what the officer is saying. Sometimes they may make certain comments that will show that their actions are premeditated and that they are actually giving you tickets for no reason. Sometimes it could be racially motivated. Sometimes it could be some other thing. The officer may be angry with his wife in the house, or may be angry with her husband in the house, and basically carrying that attitude on the way. So we encourage you to be as composed as you can, be very attentive, listen to what they say. And then if you want to talk to a lawyer, if you want to bring the case to me, I want to know what happened. I want to know the encounter. I want to know what the officer said. I want to know why he said what he said. And all these things can be used together to more or less form a formidable defense for you when the case comes up. Just for one last thing before I leave it for our judge to come in. Most of the time, individuals can actually fight most of these cases. It's not every case, or it's not every traffic offense that you engage in that you may probably need a lawyer to help you with. Again, one thing that you have to understand is that if you have not committed an offense before, if this is your first offense, I want you to have it in mind, it is always a defense. So you go to court, you are telling the judge that, Your Honor, this is the first time I've done this. And it is normal. You may have done it in the past and you did not get a ticket. The moment, if you did not get a ticket, you are good. But if it is the first time you're getting a ticket, and mostly if you go out and you're doing this by yourself, you just have to get in mind that doing it the first time, it's always a defense. And if there has been significant amount of time between the last time you did the offense and the time and the current offense that you have, it's also used as also a defense. And then we also encourage people that the moment you get into these type of issues, immediately before your hearing, make sure you actually sign up for a defensive driver course. That is very important. That will go in a way to help reduce your points if you get a point for your ticket. And that will also go in a way to also reduce your insurance amount. So that's all I would say. We'll leave the rest for questioning and answers. Thank you.
Thank you, Lawyer Christian. I think we've heard your update so far. I will now call upon her Anna Hathia to give us her presentation as well.
Hello.
Hello, Anna.
Yes, hello, good evening, family.
Evening.
I'm very grateful for this opportunity given to me. My name is Anna Hathia Amamenu. I'm going to discuss marriage and divorce. I have just 15 minutes, so I'll try my best to move over as much areas under that as possible. So I've actually made some short points that I will be having this discussion under. First of all, we're going to have a discussion on the types of marriages. We'll look at marriage under the ordinance. Then I'll also speak a bit about places where we can have our marriages, on bigamy, confirmation of dissolution of customary marriages, then dissolution of marriages under the ordinance. Then I'll also discuss some issues as to unreasonable behaviors that justifies or serves as grounds for divorce. I'll look at children, and then I'll look at property. So to steal some few lines from my brother Christian, we all get married, or at a point in time, we all get married. And we may or not get divorced, but some of us may have experienced divorce. Now, when it comes to marriage, now this discussion is focused on the laws of Ghana, or marriage solely in Ghana, not any other jurisdiction. We have monogamous type of marriages, and then we have polygamous type of marriage. Now, the monogamous type is where we have one person marrying another person at a time. And then we have the polygamous type of marriage where you can be married to more than one, a man can have more than one wife. And it cuts across the religions, whether Christian or Islamic. It's mostly seen during the, with those who have engaged in customary type of marriages. You may be a man married to one woman, but it's potentially polygamous because the man can marry another woman. There's no law against it. But then we also have our marriage under the ordinance, which is governed by the Matrimonial Causes Act. Now, under this type of marriage, it's strictly one man, one wife. And the law has gone as far as in advancing this aspect of this type of marriage. There are sanctions for couples, or be the man or woman who decides to involve himself in another marriage or relationship in a form of marriage. And that is called bigamy. And if you're found culpable of sin, based on the discretion of the judge you appear before, you might be fined or even given custodial sentence. Now, when it comes to celebration of marriages, we have so many places that marriage can be celebrated, be it church, gardens, and all that. But the most important thing is that you must make sure that the place has the requisite permit. It is not all churches that have been properly authorized to conduct marriages. Likewise, it's not every garden or grounds where you would love to have your wedding, which is properly authorized. So you need to ascertain whether the place has been properly gazetted to conduct marriages. You can also have your marriage conducted in the court premises. I mean, we always welcome it. When it comes to issues of dissolution of marriage, ideally,
what's going on?
I think, Judge, you have to unmute yourself.
Hey, Anna, we can't hear you.
Please, you're muted. Can you please unmute yourself?
Hello.
We can hear you now.
Okay, so sorry about that. So what I was saying is that you need to be certain that the place where you're conducting the marriage has the requisite permit before you go ahead and have your ceremony. And we also conduct these marriages in the court premises or as registrar general. Now, if you want to go for dissolution of marriage, if your marriage is less than 2 years, you need to convince the court. Before that, let me back up a bit. For marriages under the ordinance, unlike the customary marriage where the family can meet and dissolve the marriage between parties, with marriage under the ordinance, it can only be dissolved by the court. Now, for the customary type of marriages, if the marriage is dissolved by the family, any of the parties can make an application to the court to get an order confirming the dissolution of the marriage. And if there are properties involved, the parties can likewise go to court for the court to settle the issue on who gets what in terms of the properties that they acquired in the course of the marriage. However, for the marriage conducted under the ordinance, all these issues, property, custody of their children, that is the issues of the marriage, everything must be determined by the court. If your marriage is less than 2 years or is not up to 2 years, then you need to convince the court, give the court a good reason why it should even listen to you or consider an dissolution of the marriage or pay ear to you before the court proceeds to the actual situation or the actual marriage. The reason being that the court is not there or set up to dissolve marriages. The court wants to be certain that the marriage has really broken down beyond reconciliation. Now, when it comes to issues or factors that the court will consider in determining whether the marriage has broken down beyond reconciliation, the court expects the person who makes the petition, that is the one who comes forward that I want a divorce. The court expects the person to establish certain things. First of all, you must indicate that there's been an unreasonable behavior exhibited by your other spouse. Under the unreasonable behaviors, we have a lot of issues coming there. You must also exhibit that you guys have not stayed together for a period of 2 years or 5 years, pending the moment that you filed the petition before the court, asking for the dissolution. Now, backtracking on, to go back on the issue of unreasonable behavior. Under unreasonable behavior is a lot of things, ranging from nagging, adultery, domestic violence. Now, when it comes to, say, nagging, at that point, the court expects you to give situations, scenarios, or instances which indicate that your spouse is nagging or is always nagging. And you shouldn't forget that if the nagging is coming about as a result of your own actions, then you don't have any good reasons. So you say your wife likes nagging, you come home drunk, you come home very late without giving an excuse, and it's causing her to nag. You can't now appear before a judge to tell the judge that she just likes making noise, forgetting that you are the one causing her to make noise. Now, like I said, we also have domestic violence issues all falling under unreasonable behavior. Now, with the domestic violence, it's very broad. We have emotional abuse, we have financial, that's economic or financial abuse, we have the physical abuse, sexual abuse, all sorts of things. Now, let's take a scenario. We have this, I think recently, within this week, there's been this WhatsApp message going around about this woman who has been relying so much on her husband's salary. The man caters for everything in the house. She doesn't do anything. Then the man finds out that she's paid more than she actually told him she takes at the end of the month. She has built a house, she has bought cars, and she's even sponsoring people, all as without the man being aware of sin. You understand? Now, this is a clear case of financial abuse. You are allowing your spouse to incur, bear the burden of the family in terms of utility, in terms of maintaining your children, whilst you keep yours to yourself. That can clearly, if one party is able to establish all this information to the court, give this information and convince the court, it will amount to unreasonable behavior. In terms of the sexual abuse, you know your wife has recently given birth, probably through a C-section, always giving pressure, excessive demand of sex can even amount to unreasonable behavior, can amount to a form of sexual abuse, excuse me. Likewise, refusing to give your husband sex can also amount to a form of sexual abuse because he's entitled to sin. So under unreasonable behavior, lots of issues come into play, like I said, adultery. Now, when it comes to adultery, usually the law has a bit of a higher standard, even though it's civil in nature. We expect you to really convince us. It shouldn't just be mere inference or mere claims or accusations. One is the instances you give, which you feel justified, apart from the fact that you might have caught the person in the act. Any instances or circumstances you give must be one that any reasonable person can infer that this would lead to the conclusion that yes, this person might have actually engaged in some form of adultery. Now, that's all that aside, apart from when we have issues of divorce coming into play, the people who are usually affected are the children. If there are any issues of the marriage, there are any children within the marriage, they are the ones mostly affected. If we have a situation where none of the parties is fighting for custody, one says, I'll take the child, just give me access. fine, the court is comfortable, we'll take what the parties are providing. But where they are fighting, both fighting for custody, and the reasons being given, one says he's a drunkard, he's this, she can't take care of my case, she's like that, most of the time the court ends up giving orders for social inquiry report. The court would also ask parties to file their financial status to enable the court to give reasonable orders pertaining to the maintenance of the child. Now, under the Children's Act, on the issue of maintenance, it states that a parent or an individual who is responsible for the child must ensure that the child has adequate provisions made in terms of maintenance, shelter, health, and education. It doesn't say the man, it doesn't say the woman. That means ideally it's a joint responsibility. So at a point in time where both parties are still married, it's expected that reasonably both of you contribute towards the maintenance of your children in whatever form or manner. It might not be the same, depending on your financial status. It might not be the same, but at least there must be some form of contribution from both sides. Where there is dissolution or we are at a point of dissolving the marriage, the court will definitely be making orders to ensure that both parties contribute. There again, yes, depending on their financial status, one will contribute more than the other, but hardly is there an instance where the court says only this person, you alone take care of the child, do this, and leave one party out. We hardly do that. Usually we have family tribunal courts that handle issues of maintenance for these children and all that the men are supposedly not providing for. And sometimes you'll be surprised when they bring cases to you as family tribunal and you realize that it's not an issue of the man not providing at all, but how adequate it is. Most of the times the women are being unreasonable. Other times the men are not providing at all. But we've had situations where men are making adequate provision, but because of problems that has occurred in the course of their relationship or their marriage, the women come to court and you see that they are making huge demands. Let's say a couple with one child, you appear before the court and you tell the court that you want maintenance of 1,000 Ghana cedis. That is just maintenance, no school fees, no clothing, no shelter, just maintenance, 1,000 Ghana cedis from the man. And let's say the court finds out from the man that his monthly salary is 1,500 or 1,200. Obviously, this is unreasonable. So the court would have to make some form of adjustments in such situations. The last thing I would brush over is when it comes to properties of married couples. When you're married, it's expected that there is some reasonable form of contribution made in acquiring of properties. Now, the contribution might vary. It need not necessarily be financial. So, for instance, the woman is unemployed. The man, you are building a house. Now, whilst you are building the house, because she's unemployed, she's always at the site, making sure that materials are not stolen. She's telling the workers, do this, do that. You give her money. She goes to buy products and materials and brings to the site. I mean, you can tell she's adequately involved in the what do you call it? The construction process. Even if she's not physically doing anything, she's supervising. That is also a form of contribution. And of course, it will depend on the judge you appear before, but all of these are substantial contribution depending on the scenarios that you're able to provide to the court. Oh, my money is not involved, but Kofi Papa, you always give me 1,000 Ghana cedis at the end of the month. Since we started this, we have agreed I'll take 500 or 300 so that you focus the rest of our funds into the project. It's a form of contribution. She has made a sacrifice. You understand? But let's take for where the marriage is coming to an end. It doesn't always happen, but I had this situation somewhere last month where the parties came for a dissolution of their marriage, and when you got to the properties, now during the processes filed between the parties, you see that the man has written in his documents that yes, we acquired 3 houses in the course of our marriage, but the first house, her brothers are staying in the house with their family. So the second house, I gifted it to my sister so that she and her children will also go and stay in it. As for the third house, I agree, it is for us so we can share it. Recently, we've had a decision or a change in when it comes to properties. There's a recent decision that when couples acquire any property in the course of their marriage, you cannot gift it without the written consent of the other spouse. So I had to draw council's attention to the fact that, council, I know you stated this here, you know, we'll be taking our evidence on all that, but have you averred your mind to this case, which indicates that whilst in the course of their marriage, he could not have disposed or gifted that property to his sister without the written consent of his wife. He said, oh my lord, I am very much okay. Then I expect that whilst when you're filing your witness statement, I expect to see something to show, maybe something attached that indicates that she gave a written consent. Of course, they came back and said they want to make some amendments, which I granted, and they took that information out. But that is the position when it comes to properties now. So in the event that you are married, you acquire property, you can't tell your wife or your husband that this is my property or this our property, I've given it to this person without the person's adequate, written approval of same. I don't know if I've worked within my 15 minutes. I've rushed through a lot of things. I'm just hoping, it's marriage and divorce is a lot. It's a lot of it's a very broad area. And maybe in the course of questions being asked, I'll be able to go more into the substance of the case. But before I end, let me just discuss this under the domestic violence. In the course of a divorce I did about 3 months ago, the petitioner was a lady, and she indicated as part of her grounds that the man is always beating her, and that at a point in time she had even been hospitalized for a while. And the man denied it. He outrightly denied it. Fortunately for the lady, when she reported, the police had to be involved because of the condition she was found in, and she had her police report and all that, and she added it to her when they were filing their witness statements and all that. She was able to get a copy of same and attach it to it. Now, when parties present themselves, sometimes human as we are, we try not to be biased and all that, but it's difficult to overlook it. You are human, you need to get over it fast. But when the man who appeared before me, at no point looked like somebody who can even raise his hand on his wife. So the lady attached that, that report from the police to her witness statement. I might have just brushed over it or thought, oh, well, maybe she's just exaggerating a bit about it. I'm just being realistic, human as I am. So the little bit I can say when it comes to domestic violence in marriages and all that, we pray it doesn't happen to anybody. But if it does happen, and it happens to both men and women, it's not only the men, the society, we found a bit on how the men feel when they are beaten up by their wives. I've had situations where men come to court and say, my lord, oba we ojina ho bo obo me. Otimi so me me kosoro na ode me abehwe. And everybody was laughing there. I had to tell them that they should look at the man. He was really depressed. So please, we are hoping that nobody experiences it. But if you do, let's not take it so lightly. Let's report it and get the police involved. Let's cover our backgrounds and all that to help us progress when it comes to taking decisions about divorce and all that. So thank you very much. This is my little bit on divorce and on marriages in Ghana. Thank you very much.
I think we've been really educated tonight by our 3 panelists. I think I would actually open the floor for questions and answers at the moment, so that we don't go over the time limit too much. I think there are questions on my phone, and I've got questions here as well. Can a spouse refuse to grant divorce to a petitioner who is asking for it. And that goes to her Anna.
Okay. Yeah, sometimes it does happen that some spouse refuse to grant it, but you cannot unreasonably withhold consent. When you are before the court, you can proceed to file your divorce if your spouse is refusing. He need not or she need not join you to go to file the process. Commence the action. That's why the court has put in place service, process of service and all that. It falls under the audio or party room. That is, you've been given a chance to be heard and you are refusing to come and speak. So if you feel you have a reason why you want your marriage divorced, your spouse is not minding you, you can go to the court premises, file your process and start it. He will be served. If he refuses to come, the case will continue. Thank you.
I hope the person who asked that question, I hope you are satisfied with it. Michael.
I have a question.
Okay.
Can I go
Please
ahead?
Go on with
Okay.
your question, please.
Thank you. I have a question for our judge on the panel. So you're talking about a divorce and a marriage in Ghana. But my question is, what happens if the couple get married in Ghana under the Ghana law and they move to, say, United States and acquire their property in the United States? If they do get divorced, which law comes in? How do they deal with the properties or custodies? Are they going to be based on Ghana laws or are they going to be based on the United States laws? And I also have a question for the lawyer from the immigration. My question is with regard to having a green card and travel more than 6 months. My parents have green card and they've been travel more than a year in Ghana. They do come back with no problem. But anytime I talk to other lawyers, I get the impression that if you have a green card, you shouldn't be doing that. Is there a reason for not doing that? So those are my two simple questions.
Okay. My lady, are you going to answer that question, or I think one has to answer it first? Is it her, Anna?
Yes.
Okay, thank you.
I'll answer his question first. Okay, so what you do is that you get divorced you come down to Ghana. You come and get your divorce here in Ghana. You take your certificate and you send it back to whichever state that you are in, and then you make an application before their court for the settlement of your property. That aspect can be handled separately, even right here in Ghana. In Ghana here, we have the district circuits, high courts, and all that. When it comes to matrimonial, any of the courts can handle it. There are times that parties might have properties which are so much that, let's say 4 houses. I mean, the properties are huge and they feel they don't want the properties set between them in the district courts, but they want their marriage dissolved in the district courts. And they come to district courts, handle only their marriage, and then go to a higher court for the settlement of their property. So you can get your certificate of divorce here, take it to whatever state that you are in, and then the properties you have over there, you handle it before the courts as to how the courts will order for it to be settled between the two of you. Please, I hope that helps.
Yeah, thank you. The only problem is how the two of you can come down to get divorced. I'm sure the one who is dragging the feet may not come. Can you just come on your own and get?
We have service outside the jurisdiction. So you can come down and start the process here in Ghana, and then it will be served outside the jurisdiction. You give the address of the person, and we have processes in place. It will be served on the person. And the moment that the courts, the registrar of the courts puts evidence of service on the docket, the judge will proceed with the case.
Are you happy with that, Randolph?
Okay.
You will see me soon.
Your second question was to Lady Akuya.
Yeah, about immigration.
Lady, are you there, my lady?
Hello, I'm here. Yes. Yeah, that issue has come up a number of times. Initially, you could stay up to outside the country if you're a lawful permanent resident for not more than 6 months. But currently, the law is that you should only stay up to 1 year. I mean, so it's been extended. And if you intend to stay outside the US for more than 1 year, you need to apply for a re-entry permit. And then when you're coming, you come in with it. And for people who apply for green cards, also before you leave, you need to, apply for a travel parole document. Essentially, as a lawful permanent resident, the idea is that you're supposed to be this is where your home is, and residence is calculated by, a number of days. And so if it's more than 365 days, you may be deemed to have abandoned your permanent residency, and you don't, and of course, it's always discretionary when you get to the port of entry or at the airport and you get the customs officer. Some people may not question you as to why you've been out for so long, but other people will question you, and then they can decide to deny you entry if you've been out of the country, out of the US for more than 1 year. So it's 1 year currently.
Thank you. And just to add to that, I think also the problem comes when you want to change your status from immigration, like a green card to citizenship. That is where your continuous stay comes in. So if you do stay more than a year and you are still allowed in, when the time comes for you to file for your citizenship, that year will not be considered as your continuous stay. So you will lose a year out of your 5 years or 3 years that you are waiting to apply. Is that's correct statement, right?
That's actually right. Yes, there would be deemed to be a break in continuity in your residency requirements, because you should have stayed here as a legal permanent resident continuously for 5 years. And brief casual travels are not do not break that continuity of residence requirements. So, but if it's very prolonged and it's calculated as 1 year or more, then there's a problem.
All right, thank you.
Thank you so much, Randolph. There are other questions. Another question to Honorable Christian. How do you respond to the police when you feel like you are innocent in moving violation? Honorable Christian, is he there?
Yes, I'm here. Please, I'm here.
Okay. Did you hear the question?
Could you please repeat it for me?
Should I say it again?
Yes, please.
Okay. He says, how do you respond to the police when you feel like you are innocent in moving violation?
I think I made that very clear. You don't want to engage in an argument with the police officer. The point is that the roadside is not a courtroom. That is not where your innocence is proven. Your innocence is proven in the court of law. And so just leave it out there. Don't get into an unnecessary argument. Just leave him, and then just pay attention to whatever he says. And for the most part, as you drive around, you just begin to think about your defense and how to deal with the ticket. Obviously, I know one way or the other, most of us might probably have gotten a ticket that we think really did not deserve to have. But again, the police officer is doing his job. The roadside is his office. If he's giving you a ticket, you think that that is not the right thing he's doing, just leave it there. You go to the appropriate place to challenge it. And sometimes that is why sometimes it's also very important you involve lawyers in some of these things. And lawyers are able to help you deal with it when we strongly also believe that the ticket was not in the right, was not rightly given. Thank you.
Okay, thank you so much for giving us an update on that. There is another question to Herr Anna. It says, if you were married and divorced with a joint property, can any subsequent spouse or any further children lay claim to that joint property?
No.
Okay, so I think it's Rita. Rita, I think you've got your answer. And I hope you are satisfied with that answer. Please, do you want to ask your question? I've seen someone on it. Do you want to ask a question or? Kwame Ajimai. It looks like he's muted. Kwame, you are muted. We can't hear you.
All right. Can you hear me now?
Yeah.
All right. My question is to Her Honor. I was a lawyer in America for 25 years and now lives and practices in Ghana. My question is regarding the property distribution upon divorce. The Supreme Court, in the case of Mensah versus Mensah, and then Fenn versus Fenn, which are very contradictory in nature. So I wanted to find out if Her Honor can explain the rationale between the two judgments. Because with Mensah and Mensah, the court was of the view that the spouse or a spouse is entitled to an equal share or distribution of the property upon divorce. Now, Fenn versus Fenn comes up with a different ruling altogether. And my question is, can we get a better explanation as to how the court made a severe departure from Mensah versus Mensah and then came up with the Fenn versus Fenn case?
Council, if I may answer. Council, thank you very much for your question. I wish I could give a justification as to why my lords have decided that this should be the new way forward. But you agree with me. I'm a circuit court judge. Like you said, the Supreme Court has given a decision. Yes. So whether I like it or I don't like it, I'm bound to follow it. But at the end of the day, the lawyer who wins his case is the one who makes a good grounds or gives a good standard. I mean, there are instances where lawyers have even won cases on dissenting opinions. So irrespective of the current position of the Supreme Court, and I have no standing to subject it to interpretation or justify why the court gave that decision. As a circuit court judge, it's totally binding on me. So I'm unable with this particular question. I'll have to raise my hands. I cannot justify why my lords.
So okay, all right. The justification aside,
Yes.
I mean, what is your personal opinion in terms of if a woman was in a marriage for, let's say, 20, 30 years and assisted, substantially in raising the children, raising the home, and then upon divorce, right, the court can use Fenn versus Fenn and say that they did not make any substantial contribution to whatever wealth that the man may have accumulated. And so therefore, she walks away with, substantially less than what she could have been entitled to under Mensah versus Mensah.
Okay, so when it comes to that, from my personal point of view, I've had cases where I have gone both ways. Okay, so I've had cases where councils will come and say the woman did nothing in terms of giving any financial contribution. She just stayed home, she just took care of the kids. But like I said at the initial stages, it depends on the nature of scenarios that you give to me. We have a woman who did not give any financial contribution, but she was seated at the site where they were fixing things. At a point, she was even carrying water. You understand? You give those kind of scenarios that make it so obvious that even though she might not have given financial contribution, the help she offered is one that the court cannot just brush over. Then I'm inclined to still, even though the Supreme Court says, reasonable contribution, it's my opinion. So I would say that in my opinion, the person is entitled. Likewise, I've had cases where the lady claims I've contributed, but she was unable to give any good grounds. Let me give an example. So I had this lady who says she started life with a man, he had nothing. Now they have a 16 bedroom house, and now the man is asking for divorce. She can't have children. The man has had so many children outside, and she says, I contributed, even I was not taking chop money, this and that and that, but taking chop money. So who was providing food for her? Then she would say, and the man will sometimes go and then bring food to the house. So her points, even though she was saying she has contributed, she wasn't giving me any solid grounds to even turn my opinion to exercise that discretion in her favor. So yes, Mensa versus Mensa used to say that you are entitled to equal share. Finn now is saying that establish some level of contribution, but at the end of the day, it's at the discretion of the court. And depending on how, even if it's some minute form, it is still my discretion, it's still my opinion. So if I'm convinced that this is not something I can just brush over, I'll exercise it in your favor. I mean, appeal that. That's why we have the appellate courts, the higher courts. Any dissatisfied party can go up. But yes, you're following the law, but you don't follow it blindly, especially when it says you have a chance of exercising the discretion based on your opinion. I hope this helps.
But what about PLC law 111?
What about?
Well, let her Honor answer that because she is the judge.
What about it, please?
Yeah, how does that come into
it deals
play
with interstate
versus Mensa?
Yes, that's with interstate. We are talking about properties acquired in the course of marriage, where parties come for dissolution. And Mensa initially established that you are in equal share. Whether you contributed, you don't contribute, you're entitled to have 50-50. But with the recent decision, they're saying that you must establish some level of contribution. And counsel initially wanted to know what my opinion is about the Supreme Court's decision. And I'm saying that looking at where I stand as a circuit court judge, I'm just supposed to apply the law as they provided, the decisions as they provided. And I cannot put myself in a position where I question it. But when it comes to its application in my courtroom, well, it's my opinion and it's my discretion. So if the Supreme Court is saying that the party must establish some form of contribution, and I feel what you have told me is enough, I will exercise it in your discretion. The aggrieved party can go to the appellate court for another opinion on same. So that was what we were discussing.
Okay.
Honor, I look forward to coming to your courtroom someday.
It will be a pleasure to have you, counsel.
I think Obra has raised his hand.
Yeah, yes, I have two questions. One is on about tickets. For example, question is, how long do they hold the tickets in the courts? For if you have a ticket and you said that I want to come to the court to dispute, and it's not scheduled, because recently, because of the pandemic, all the courts in the US, you couldn't schedule any tickets at all. So in that case, are they gonna just hold on to it for life, or are they gonna make a time for you to come in? Because they have to schedule it and they don't have time for the courts to hold, and they have a lot of cases available. And also, are the tickets kept forever, or is a time limit to them? The second question is about the marriage and the dissolution. If you look at our fathers in the past, all this marriage took place in like they go to the family's house and say they are married. There's no paper to prove that. There's no marriage certificate at all. So if somebody brings this to court, is the court going to ask them to show their marriage certificate, or they are going to call somebody in the household and say, okay, were they married at all, before they agree to whatever their decision you have to make about dissolution? Or in that case, unless that one is not handled by the courts, it's only handled by the household where the thing took place.
I think Anna, can you give us an answer to that? And then when you finish, Honorable Christian will answer the first question.
Okay, So in respect of the scenario you have just given, that is for customary marriage. And for customary marriage, if the marriage is dissolved in the house, like I initially said, you go to the court for a confirmation of the dissolution. If you had customary marriage, but you want to go to court to dissolve it, well, the court, you were not given a certificate in the first place. So the court will not bother itself about, provide any certificates. You proceed to take your evidence after they filed the necessary, processes. So you need not present a certificate if you were not given a certificate. But if you were given a certificate, such as the as provided under the as you'll be given under the ordinance, those who get married under the ordinance, registrar general in the court, in the church, you are giving that the green certificate. Yes, if you lose it before you make your application for the divorce, then you go to registrar general, depending on the district that you are in. If you are in Accra, you go to registrar general. They usually have a copy. If you had the marriage in the court, there should be an extra copy. They could always get you a certified true copy, or the assembly, sometimes you from the church. It all depends on where you had the marriage. But if you were not given a certificate to begin with, the court would not expect you to have one. Thank you.
Thank you.
Honorable Christian, the first question, please.
Yes, right. Please, regarding the first question, I just wanted to make an example. I got a ticket in 2013. I defended it in 2016. That was in the state of New York. So for the most part, if your case has not been scheduled, normally the court will schedule it. If they don't schedule it, that is good for you. I mean, you don't have to go and defend it. But for the most part, they do schedule these cases. I mean, as much as no matter how long it takes. For those of us who are in New York, New Jersey area, we've had most of these cases virtually. The courts have had, some of the courts use Zoom systems, some of them also use these. There's one for Microsoft meetings, Microsoft meetings also. Then so the cases are going on pretty well in some jurisdictions. But in case your case has not been called yet, or you've not been scheduled for a date yet, just wait patiently and then wait for your turn. If they don't schedule it, I think that is good for you. But for the most part, you just have to wait. The cases can be in the court. In respect to most of these cases, they can be they can be in the court system for so long a time. And for people who have defended cases or who have had a lot of tickets in a jurisdiction like New York, people are just fond of just postponing or seeking a continuance on their case, and with the hope that when the time comes and they show up, the officer who gave them the ticket will not show up. And if the person does not show up, it means your ticket is going to be dismissed. You don't get to pay a fine. You are free to go. And so for the most part, people have actually continued their cases or postponed it for years. They come in, they always have reasons for the judges to kind of postpone the cases for them. And I think that is good for you. If the officer who gave you the ticket does not show up, the ticket will obviously be dismissed. So that is something that you have to keep in mind. All right.
Thank you.
Okay. O'Brien, have you got your answers? Are you happy with the answers? And
yeah. The question was that is there a limit to how long the tickets can stay in the courts? And from what he said, there's no time limit. So yeah, that's what he's saying. That was the key. And then the other one was the customary marriage. And the customary marriage, when there's a property involved, I don't know how that one is handled. It cannot be handled by the courts either. It has to be handled at home, unless that one is not. That's the way it is. Because if the customary marriage, there's no certificate, there's nothing. When they say we are married, but if there's property involved, what happens? So we just have to sit somewhere and decide on it, and unless the courts can come in on that one also. Is it possible?
For the matrimony.
is that question for her Anna?
Yeah, if her Anna can address that. No, there's no certificate, but if there's property involved, that's what I'm saying. Properties are registered to individuals, but that one there's a certificate involved. So did they come in? Because they won't come in for the divorce, but for property, I think it's a different story, right?
If there are properties involved, definitely the court can resolve that issue. If you remember, I indicated that even with those with the certificates, there are instances where parties might, the nature of the properties that they have, they feel that they would need a higher court to resolve that issue. So you see them coming to a lower court like the district court or to the circuit court just for the dissolution of the marriage, and then they go to the higher court to settle, for the court to determine on who should be settled with what property. So even with the customary marriage, it's the same thing. You go to the district court or any other court for a confirmation of the dissolution of your marriage. And when it comes to the properties, the court can also determine who gets what. And it will be the same application of the same principle, who has made contribution and all that. So the fact that it's Kashmir does not mean that the property you acquired has to be, resolved or settled in the house. The court can handle it.
Thank you. I think I'll now call Simon. He's raised his hand for a long time now. Simon, can you ask your question, please?
Yeah, I'm glad that Honorable the Judge mentioned it in answering Obra's question. A few years ago, an immigration lawyer who was handling the deportation case for Ghanaian approached me to write a letter to the court to talk about customary marriage, because obviously the client, the Ghanaian, someone has reported him that he was previously married in Ghana and didn't get divorced from his wife and has married again in the US. And that was the whole story for the deportation. And they approached me because I'm a chief in Ghana. And my letter was that in the customary marriage in Ghana, the marriage can be dissolved when you send your folks back home to go and return the drinks or whatever to the other side, and that's it. There is no court issue or anything involved. And so whatever the case is, if the person says the marriage was customary and the divorce has occurred, the court should accept that. In fact, I was going to ask the judge to add to that if I did right, but I think she has already mentioned that in some way.
Okay. Nana, what's the scenario you're giving? It does happen a lot because it's customary marriages. Most people don't, like my brother Obra asked the question about this sharing of properties. Most people just dissolve the marriage among the family. Okay, you take this house, I take that house, they go their separate ways. So it's not surprising, it happens a lot. But usually when they have to travel outside the country, and for purposes of these documentations and all that, they do that. They would now come to court and ask for confirmation. And for some people, even with the customary one, they just also want to come for confirmation. So it's not getting confirmation from the court for the dissolution of the customary marriage. It's not something people do a lot, but it's something that they should be doing. So I understand how that scenario may have come about, Nana. It happens a lot.
Okay, Nana. So question answered now, yeah? Let me move on to the next person. A question here from, I think it's Christiana, says, Your Honor, you talked of physical abuse. Can emotional abuse be basics for one to file a divorce? And that's to her, Anna. Should I ask the question?
Please, can I get
it again?
Yes,
should I read it again? Okay.
Yes, please.
She says, Your Honor, you talked of physical abuse. Can emotional abuse be basics for one to file for a divorce?
Yes, emotional abuse can be a basis for filing a divorce. But from my personal experience as a lawyer before I became a magistrate and then a circuit court judge, you need to, unlike the other instances or grounds for divorce where you can go to the court premises even without a lawyer, if your basis include emotional divorce, I would advise you get a lawyer to help you, because depending on how you couch your pleadings or your claims before the court, if there are children involved, you stand the risk of creating an impression as though you might not be stable or in a position to take care of your kids. I had a similar situation when I was in private practice. At that time, I was at Yoku, but I had a pro bono case. And the lady's main grounds was emotional abuse. And we appeared before this, at that time, she was a circuit court judge. And I kept focusing on the emotional aspect. And even though we won the case, at the point in time, the judge advised, said, counsel, you need to be very careful because you're making your clients look as though she might not be competent to even take care of her own kids. You understand? And for me, at that time, I was also quite young, a young lawyer, and all that. I needed a bit more experience. So I would advise that if your grounds includes emotional abuse, yes, it's a good ground for filing the divorce, but seek legal advice. Get a lawyer who deals mainly with divorce cases to help you, such that you might not end up looking, even though you are the victim, you might not turn out to look as though you are not even competent to handle your kids, because the court will be looking out for your welfare as well. You understand? Yes. I hope it helps. I hope my answer helps you. Thank you.
Thank you. And another question. It says, what happens if in the case, in the course of filing for divorce, you find your spouse has sold one of your houses without your knowledge?
So what happens is that depends on the lawyer involved in the case. Ideally, most lawyers will still file the process and indicate the house in question. They will list the house in question as still being part of your properties, because like I indicated, there's even a decision about gifting houses or gifting properties without the written consent of your spouse. How much more finally disposing of same? So your lawyer might, or your lawyer will include that as part of your distance, as part of your reliefs from the courts, and will ask for 50% of same. If 50% or more, depending on the kind of lawyer you have, but if I'm your lawyer, I'll still ask for 50%. Yes, I'll list the property. If he sold it, he has taken the proceeds of the property he sold, so he should give you your share. Thank you.
I'm sorry, interrupted you. Sorry, I interrupted you.
No, it's okay. I was just going to say that I hope that helped the person.
Okay. I think I saw another question. It says, if the woman contributes substantially, can she lay claim of property on the unfortunate passing of her husband?
Okay, so in respect of this question, there are two folds. Whether the deceased spouse left a will. If he left a will and the will does not direct that property should be given to you, then obviously you can't lay claim to it. You can't lay claim to it. But if he died without a will, then that is a different situation altogether. That the surviving spouse, you must apply for letters of administration. Along with the family or without the family, you must get a letter of administration, and the properties of the deceased can then be dealt with according to the law. You can't just lay claim to it automatically because he was your husband. If he left a will and left the property to you, that is different. If he did not leave a will, you must obtain letters of administration to be able to handle the estate of the deceased person. Even though he was your husband, that is the right thing to do.
And he asks again that if the husband had willed property to his family.
Am I allowed, please?
Honorable Christian.
Yes, please.
Okay.
Yes. Yeah.
Okay.
In fact, I was just shocked by what Yona said, especially when in regards to the issue of the wills in Ghana. I think in the US, most states, you can't take your spouse out of your will. Most states you cannot. In most states you can't do that, because yes, you cannot really take your spouse out of your will unless. I mean, I don't think I've not seen a scenario where courts have really allowed that. If you do that, there is an elective share that your wife will be entitled to, and so she can actually go to court and make an application, and the court will give her that percentage. And normally, is your wife will be able to get about $300,000 of what you left, and then 1/3 of the remaining. So in the US, it's a completely different situation. For most states, you can't do that. You can't take your wife out of your will. It's abominable. Yeah. So I just wanted to chip that in.
Unfortunately, in Ghana, it's not automatic. Like you said, obviously, if the wife is taken out of the will, the court will always make provision. There's been so many instances such as there are lots of decided cases where spouse have willed properties and left the surviving spouse out, and then they make application to the courts given what they are due. So unfortunately, in Ghana, it's not automatic. If the person has a will in place and leaves you out, at best you can go to court, and then the court will definitely make some provisions for you, and that will also take the due process. It's not automatic. It will follow the regular course of trial for that determination to be
made. I think
and if I want to, if I may supplement what Anna said, there's a provision in the Wills Act which allows judges to hear the case of the surviving spouse if the deceased spouse does such an act. So that will be up to the surviving spouse to prove that they either were a spouse at the time of the deceased person. So an application will have to be made, just like Anna said, and I think it's captured in the Wills Act. Yeah. That's all I wanted to say.
Okay. Okay. Thank you. I've got Kwejo Poku. Actually, his hand is up. So I will just invite him to talk, to ask his question now when he finishes.
Yes. Thank you, Your Honor, Hadia, for the presentation. Yeah, I would like to define specifically what do you mean by emotional abuse to necessitate a divorce. And also my second question, does the codicil supersede the actual will?
Hannah,
this question goes to
Hannah, please, did you hear him? Hannah,
you want me to repeat?
I had been muted, sorry.
Okay.
Aspects of the emotional abuse, like I said, it all depends on the information you give. But emotional abuse can range from constantly insulting the person for no reason. Let's say insulting, I've not done anything to you, you're always insulting me, you disgrace me in public, anything that can cause the person's conduct or demeanor to change at an instance. Any acts that you put up or you inflict upon a person by way of your actions or by way of verbally, which can cause their demeanor. And you can tell when you are with two people, you are there, you can tell how the person is. You shout out a word or tell the person you cannot watch TV anymore, get out of my room. These are, like I said, it's based on the information you give to the court when you are making claims of emotional abuse. But when we say emotions, I cannot tie it all down to one thing, but anything you do which can change a person's demeanor and make them feel down, make them feel as though they are not needed, I think it all suffices to establish emotional abuse. In respect of the second question, I must say, you were asking whether a codicil, can you repeat the question again, please?
Yeah,
I think
does a codicil supersedes the actual will or what?
Okay. For this particular question, I'll have to opt out. I'm not, I don't know much about wills. I know there is a lawyer on standby here, one AkataSlopsa can jump in. I mean, we can't all know the law. The law is in my bosom, but it's always good when you are not certain about a response to seek somebody else's opinion. So in respect of that, I'm unable to help. If my lady Ivy will give the opportunity to cancel the AkataSlopsa, I've forgotten council's name.
Christian.
Yes, I think he spoke a bit about wills. Maybe he's practiced more about wills to answer the question for me. Thank you.
Are you ready to talk?
Yes. Yeah, and I can speak in respect to my experience in New York, the New Jersey area, New York, New Jersey area. Yeah, normally the codicil will take precedent. I mean, the codicil will be an amendment to the will, and so if you are changing entirely everything in the will, in the codicil, it will become it will be seen as the will. Again, we know that the codicil will be passed the same way the will is passed. So if you've gone through the formalities and gone through that process, then it becomes the document that the courts will look at when these things come up. But Your Honor, I had a question, and I wanted to know how you. Please, I hope I answered. I hope my answer is okay before I go to my question.
Yes, please. You can continue.
All right.
That's perfect.
Yes, I had a question.
Thank you, Christian. Yeah, thanks. That's answered my question. Thank you.
All right. Thank you very much, Senior. My question pertains to the allocation of or the allocation of property in terms of when the divorce is ongoing. I know there are properties that are termed marital, others are personal or private. So how is it done? Which of the properties, and especially in the Ghanaian jurisdiction, are going to be deemed as personal or private in the course that are acquired in the course of the marriage? Could you educate us on that?
Okay. So in trying to answer the question, I'll give an instance of a case that I've handled before. So we have this divorced couple appear before the court, and the man has his personal cars that he purchased in the course of the marriage. He bought 2 cars for himself. He bought a car for the wife. He bought other stuff. They built a house together. He has an office, a story building where he has offices and stores. He actually built 2 and gave one to his wife. The property is in her name and the other one is in his name. Now, when it came to the dissolution of their marriage, in terms of the property, the man insisted that the story building which he had in his name is for him, and the one that he gave to the lady is for her. And he was also insisting that the 2 cars should be maintained as belonging to him because he already bought a car for the lady. Of course, the lady when she filed her processes, she was demanding for a share of the other one, insisting that what she was given has 4 stores, whilst the man has about 10 stores in the other building. So she was insisting that some other stores from the building the man has in his name should be given to her. And that for the 2 cars that the man has, the court should make the man sell one of the cars and the money should be kept in the bank for their kids. Obviously, in such a situation, you can tell that issues of what comes into play during the trial is that I expected the woman, of course, I didn't grant for all that she was requesting for, because at the end of the day, if you look at my reasons for that, I indicate that she was unable to establish that those properties, she had made any form of contribution to it. and reasonably, considering the fact that this man bought a car for you, he also built a similar property, even though the number of stores is not the same. If he intended that that property should be for the two of you, he would have kept your name on it. That means he intended for it to be for himself, and he even gave you what belongs to you. So looking at using such a scenario, there are situations where each of the parties, although they are married, may have properties that they say, this one is mine, I acquired it myself, and I want to keep it myself. And based on the the information that they will give us, you can clearly make a decision. Of course, it's your opinion. Someone else, a different judge might take a different decision. But in my view, in such a situation, the man is entitled to the properties he bought himself and maintained his name without any evidence indicating that the woman had any contribution to same. You understand? So most of the times, me personally, someone would say that, then what about issue of this substantial contribution and all that? It depends on the number of properties you have. It's all an issue of, for me, how reasonable the claims you are making is. If you have only one house or only one car, and the man is insisting that this house belongs to me, I acquired it for myself, but it was acquired in the course of the marriage, but the woman states otherwise, then I would expect her to give me something that would justify my saying that you have given me evidence of having made adequate contribution. So the property should be shared between the two of you. So it's reasonable that the court, after hearing some evidence from the lady and being convinced, will give such an order. But where the man has made adequate provision for both of you, and then you still make unreasonable demands such as this, then I think most of the times you find the court allowing the man to have such property settled in his favor. Christian, I hope, does this help?
Yes, Your Honor, it does help. But I just a little follow-up. So in this scenario, when you're making a decision, are you going to assess the value of what is of the product or the properties they're fighting about? Especially, and I'm also looking at a scenario where you have a woman who is able to work, and I know very well in Ghana it's very rampant. Many male spouses will tell their female spouses not to work; they should stay home and take care of kids. My wife is a corporate lawyer. I have a private practice. Then I tell my wife, stay home and then don't practice your law. And then I buy stuff for her and I buy myself. I mean, all the luxury stuff I do purchase. So in that case, would that also be considered if the woman is able to do so, but then has been pushed by the man to stay home?
Yeah. Yes, all that would be considered, because if you ask the person not to do any work and that you take care of the person, then reasonably it's expected that you knew what you were going out for and that you were setting out to build something for the two of you and not just yourself. So in such a situation, irrespective of the fact that the woman was not working and didn't give any financial contribution, if at the end of the day, the evidence she's providing pertaining to her contribution in any form or way is not adequate for me to give the order for the property to be shared in her favor, then I have the discretion of directing that she should be paid some amount of money in lieu of settlement of the property. I can do that. It's a discretionary award of the court. So if in my personal, in my personal experience, where I have such a case where the woman has not agreed,
oh my God,
can give some form of
Hannah. Hannah, you muted. Hannah.
Actually, she is not muted. It's just the network
connection. Okay.
Yeah.
So the connection has it ceased though? Hannah, are you there?
It looks like her internet connection is a little bit.
Yeah.
So she's going to get back. So I think I'll go ahead and have
have other people in the audience asking, questions, and the questions are all about marriage and divorce. And so if she can't, I don't know what's going on there, but I'll be very brief. Okay. Hannah.
Yes, hello.
Okay.
Sorry,
you are having problem with your connection.
Yes.
I'm so sorry.
Okay. So what do you call it? Council Christian, I don't know. I hope what I said was helpful. Did they answer the question?
Oh yes, it did. Thank you.
Okay.
I've seen Kwabene Kyoko also raising his hand. Can you ask your question?
Thank you very much for the opportunity. You have, I joined a bit late, so all I heard was about statutory marriages and customary marriages. What about couples who have just been cohabiting? For instance, people could be living together for 5-10 years, not legally married by any means, whether customary or statutory. In such situations, in the jurisdiction of Ghana, what happens to the settlement of property if they decide to go their separate ways, or there was if they decide to go their separate ways, what happens with people who have been cohabiting, working together, doing everything together, with or without children? If it happens like that, what are the rights of either the male or the female in the relationship with regards to property distribution?
Anna.
Yes, when it comes to property distribution, like I initially started discussing about the courts resolving same. It's not always the case. We even have situations where both they engage the services of a lawyer, and sometimes councils come with terms of settlements pertaining to how they want, who wants to take what. So it's dependent totally on the parties. The court looks out for whether the marriage has broken down beyond reconciliation. But when it comes to issues of property, if both of you have a lawyer, you can engage the lawyers, you can sit down with the lawyers, and then you come to an agreement. This property, okay, this person should take it, that property, that person should take it. And when they bring it to the court after, during the course of the trial, they inform the court, it can be adopted as consent judgments. It will be filed. The court will adopt it as its consent judgment pertaining to the settlement of the property.
Okay, thank you. I'll now call Ojojo as the last person, because I really don't want the meeting going on after 10 p.m. And so Ojojo is the last person to ask his question. Ojojo, can you come on and speak to him?
Thank you very much. I was just listening to where the lady was talking about when a man says the lady should stay home and he would finance everything. I was looking at, well, he's financing everything, but for the lady, educating herself and maybe empowering herself, like if she was working or if she was in education, that would be her benefit. She's at a loss there. So how does that work?
Anna,
Okay.
did you hear the question?
Yes, I heard the question. Like I said, such scenarios where you've been asked to stay home, you stay home, you don't educate yourself. I mean, you let yourself go to take care of the family and all that. If you give the court all that evidence during the trial process, it will all be considered. The court always has a discretion of awarding what do you call it? This monetary kind of compensation if the court feels you're entitled to same. So it cannot be considered through what do you call it, the award of monetary compensation. The court cannot order him to send you back to school or anything like that, but at least some amounts can be awarded in your to make amends. Before that, I was just glancing through. I know my lady says we are about to end very soon, but I realized that there seems to be a lot of questions about this emotional abuse and comments on it. But I feel maybe I didn't clarify it well to the understanding of most people. What we are saying is that people ideally, let's forget physical abuse. Let's forget issue of adultery. Let's have a situation of unreasonable behavior, focus on emotional abuse and nagging. I'm not there with you when such instances occur. The only way you can establish it or prove it to the court is by giving instances. And it has to be instances that when the court looks at it, you can make an inference that no, this one is either too much. It's obvious that the person is being unreasonable. So if you have a fight with your spouse, which we all do, and you are not talking to each other for 2 days or not minding each other for 2 days, yes, it's not right. It's not fair. It's not right. It's a form of abuse on its own, but it's not an automatic grounds for divorce. As in, you just jump up. It's happened once, you go for divorce. No. Most people who come and rely on the claim of emotional abuse, it has not happened once. It has not happened twice. It's for a period of time. So if we shouldn't, I hope we don't take it lightly that just a cold shoulder given, yes, it's emotional abuse, so it's total grounds for divorce. No. The court is not looking out for a lot of divorce. We are hoping you don't bring us a lot of divorce. Okay, thank you very much.
Okay, I think I will ask her Anna to give her closing remarks. And then when you finish, then I'll ask Honorable Christian and Lady Equia to also give their final remarks, for closure.
Okay. So, family, thank you very much for this opportunity that you have given to me to express my views and my opinions about the position of the law pertaining to marriage and divorce as it stands in Ghana. I'm grateful for the questions, as it has also been a learning point for me, because sometimes you've also left some aspects of the law somewhere and then you are asked the question and you realize, no, I need to go and refresh my memory. So I'm very grateful to this big family for the opportunity and the platform you have given to us. Slopsans, Akatechi, long live this big family. God bless us all. Thank you very much.
God bless you too, hey Anna. Okay. Next is Honorable Christian. Can you give us your closing remarks?
Oh, yeah, Your Honor said it all. We are grateful for the platform to also share our knowledge on these topics. Regarding the traffic issues, again, we've summed it up. Please, when we are driving, we should make sure we have our eyes, our attention on the road, and we are keeping our speed to check. And then we also have to make sure we don't drink excessively and then be behind the wheel. That could lead us to a path. Apart from the fact that you could get into an accident, you could lose your license to drive. So please, let's be very careful on our roads. Thank you.
Thank you so much, Honorable Christian. And then finally, Lady Equia, can you also give us your remarks for the night, please?
Thank you so much, Lady Ivy. I've had a wonderful time learning from everybody here. I had a great time also discussing U.S. immigration law. Don't forget that if you have any type of U.S. immigration law problem, you need to consult specifically with an attorney. This discussion does not in any way constitute legal advice for your situation. So with that disclaimer, thank you guys and have a wonderful night.
Thank you so much, Lady Equia. We are very grateful. I think it's been a wonderful evening. I'll take this opportunity to thank our panelists for coming and for a successful program. Thanks to our audience for honoring our invites, and have a good evening, you all. Thank you so much.
Any item 13 or?
Thank you.
It's
panelists.